Okay, let's talk about informed consent. I told you that I wanted you to have reasonable information to give informed consent. Reasonable knowledge, given reasonable information to give informed consent. Okay, I'm getting this out of the law books, okay? So many of the rules of professional conduct require a lawyer to obtain the informed consent of a client or other person, e.g. a former client, or under certain circumstances a protective client, before accepting, continuing representation, or pursuing. Okay, the communication necessary to obtain such consent will vary according to the rule involved in the circumstances, giving the need to obtain informed consent. The lawyer must make reasonable efforts to ensure that the client or other person possesses information reasonably adequate to make an informed decision. Ordinarily, this will require communication and includes a disclosure of the facts and circumstances giving rise to the situation. Any explanation reasonably necessary to inform the client or other persons of the material advantage or disadvantage of proposed course of conduct. Of the client's or other person's options, alternatives. In some circumstances, may be appropriate for a lawyer to advise a client or other persons to seek advice of other counsel. A lawyer need not inform a client or other person's fact of implications already known to client or other person. Okay, so this is giving you a whole lot about what you need to give informed consent. You have to give informed consent before any proceedings. Anything can go before trial. Okay. It even tells you about fraud, which happens because they're not abiding by the rule of professional conduct. Okay, let's see. Confirmed in writing. So when they get confirmed in writing, you know, if they ask you if you knew anything I'm about to tell you about, that's a hard no, okay? So I'm just showing where I got this. It's rule 0.1 terminology, okay? So it'll be all the way at the bottom, okay? Be down here. You'll find it. There it is. Okay, informed consent. Now, okay, this is the Illinois, but I would use the American Bar Association in most states. Okay, now the court rules. Let's go back. Preamble, terminology, okay, I just want to get to the rules really quick. Okay, here's the rules. Preamble, a lawyer's responsibilities, scope. I already went over terminology with you. Okay, competence. A lawyer shall provide competent representation. Competent representation requires an equal knowledge, skill, thoroughness, preparation. Okay, so they went to law school, so they may appear competent. Okay. But failure to be diligent, this is diligence. People used to laugh at me when I would talk to lawyers because I would just use simple terms. A lawyer shall act with reasonable diligence and promptness in representing a client. should pursue a matter on behalf of the clients despite opposition, obstruction, or personal inconvenience to the lawyer, and take whatever lawful and ethical measures required to vindicate a client's cause or endeavor. A lawyer must act with a commitment and dedication to the interests of the client and with zeal and advocacy upon the client's behalf. A lawyer is not bound, however, to press for every advantage and realize for a client. Okay, so diligence, communication, that rarely happens. Lawyers shall promptly inform the client on any decision, circumstances, respect with the client's informed consent. Informed consent. Remember, I brought that up first. As defined, reasonable consult with the client by the means which client objectives are to be accomplished. Keep the client reasonably informed about the status of a matter. Promptly comply with reasonable requests for information, like basically anything in discovery, which that rarely happens. Consult with the client about any relevant limitations of the lawyer's conduct. The lawyer shall explain the matter to extent reasonably necessary to permit the client to make informed decisions regarding the representation. Okay, so he didn't communicate that to you. Remember, if you're not, it's hard to violate one rule without a lack of communication is a lack of diligence. All right. So one must be diligent in communication. All right, so it's conflict of interest. Okay, there might be other things that you might use. I'm trying to just go for the criminal courts right now. Okay, client with diminished capacity. I'm helping somebody with Social Security whose brother has a diminished capacity. Handicapped one way or another, physically, mentally. Declining or terminating representation. I had a lawyer do this to me, just quit hot on the spot, just right there on the spot. Lawyer shall not represent a client to where the representation is commenced, shall withdraw from the representation of a client. The representation was a violation of rules of professional conduct or other law, lawyer's physical or mental condition. A lawyer is able to discharge except stated paragraph. A lawyer may withdraw from representing a client if withdrawal can be accomplished with material adverse effect to the interests of the client. The client persists in action involving lawyer's service. The lawyer reasonably believes is criminal or fraudulent. The client has used lawyer's service to perpetrate a crime or fraud. The client insists upon taking action. The client fails to substantially. See, they always say the client fails, but they never mention in here if the lawyer fails to do this, and they fail to do this. Okay, the representation will result in unreasonable financial burden of the lawyer, other good causes. When ordered, a lawyer shall continue representation notwithstanding good cause, terminating upon termination of representation. A lawyer shall take steps to the extent reasonably practicable to protect the client's interests, such as giving reasonable notice to the client, all owing time for the employment of other counsel, surrendering papers and property which the client is entitled, which is discovery, the file, and refunding any advance payment for fees and has been earned or incurred. The lawyer retain papers retailing to the client to the extent permitted by law. I worked with many lawyers and they don't do that. So, duties to a prospective client. I've seen people go to talk to lawyers that they weren't any longer using, and I told them they still are an upcoming client, but past clients too. Duties to prospective client. Person who consults with a lawyer, responsibility for forming a client lawyer with respect to the manner and prospective client. Even with no client-lawyer relation, assures a lawyer who has learned information for prospective clients shall not use or reveal that information. Shall not represent a claim of interest materially adverse to those prospective client in the same substantial. Okay, so lawyer serving meritorious claims and contentions. Meritorious claims and contention. Lawyers shall not bring forth, defend a proceeding or assert, convert an issue therein unless there is a basis in law and fact for doing so that it is not frivolous, which includes good faith argument, extension, modification, and reversal of existing law. A lawyer for the defendant in criminal proceedings or the respondent in that proceedings that could result in incarceration may nevertheless so defend proceedings as to require that every element of the case be established. Okay, meritorious claims. Okay, so basically you can't come into court and assert a crime you can't prove. A lot of times people just go in there and point the finger. In criminal cases, I've had those thrown out on probable cause hearings. I've had the public defenders get mad, the judge get mad, but it's your right to a probable cause hearing, and you can have that case thrown out on the first day you appear because there's no meritorious claims or contentions, something that can't be proven, okay? Often called slap suits. Fairness to the opposing party and counsel. So if it's not a criminal case, you might want to use this. A lawyer shall not unlawfully obstruct another party's access to evidence, unlawfully alter, destroy, or conceal document or other material having potential evidentiary value. A lawyer shall not console or assist another person to do such acts, falsify evidence, consult to assist a witness to testify falsely or other an indictment to a witness prohibited by law, knowingly disobey an obligation of the rules of the tribunal, meaning the rules of professional conduct or the code of judicial conduct, except for an open refusal based on assertion no valid obligation exists. Okay, so there's a lot you should really catch on. Impartiality, trial publicity, lawyer as a witness. Remember I was telling you about special rules of the prosecutor. That's the only extra rule for criminal court. All the rules apply in every court, no matter what court you're in, except for Rule 3.8, and that's the extra one for criminal cases. Special responsibility of the prosecutor. The duty of a public prosecutor to seek justice, not merely to convict. The prosecutor in a criminal case shall refrain from prosecuting a charge the prosecutor knows is not supported by probable cause. That's why I always push people when they go in there, ask for a probable cause hearing. You get a probable cause hearing, it could be thrown out on the same day. Some guy was protesting and I talked to him about it. He smarted off to a cop. The cop ran up on him, arrested him for I don't know what, but it got thrown out on no probable cause hearing, okay? Make reasonable efforts to ensure the accused has been advised of the right and to procedures obtaining counsel, and give reasonable opportunity to obtain counsel, not to seek or obtain from unrepresented accused of waiver important pretrial rights. Make timely disclosure to defense of all evidence information known to prosecutor tends to negate the guilt of accuser mitigates the offense in connection with sentencing, disclosure, defense, tribunal, unprivileged mitigation information known to prosecutor except prosecutor revealed in responsibility protected order by a tribunal, not subpoena a lawyer. Okay, so you're going to want to go now all the way at the end. When a prosecutor knows of new, credible, and material evidence creating reasonable likelihood that convicted defendant did not commit the offense of which defendant was convicted, the prosecutor shall promptly disclose evidence to the appropriate court authority. 2, if conviction was obtained in prosecutor's jurisdiction, promptly disclose that evidence to the defendant unless authorized. Delay and undertake further reasonable investigation or reasonable effort to cause an investigation to determine whether the defendant was convicted of an offense that the defendant did not commit. H, when the prosecutor knows clear and convincing evidence established the defendant is prosecutor's jurisdiction was convicted of offense the defendant did not commit, the prosecutor shall seek to remedy the conviction. The prosecutor's judgment made in good faith that evidence is not raised to the standard state paragraph 3 or H through subsequently determined have been erroneous does not constitute violation of this law. Okay, so that's probably why the Supreme Court, U.S. Supreme Court, shot down somebody's petition for overturning a wrongful prosecution on exculpatory evidence, and the Supreme Court shot it down. And it's probably because your state's attorney didn't do it. Okay, so remember, when you go there and ask the state's attorney, to overturn that wrongful conviction, okay, don't forget to ask them, okay, to be diligent, and expediting that litigation would be competent, okay, because there's expediting litigation down here. Fairness to the opposing party, lawyers, truthful in statements to others. That doesn't happen. Communication, dealing with an unrepresented person, respect the rights of responsibilities of partners, managers, and supervisors. That's probably why Kim Fox, from Cook County State's Attorney, she did recuse herself, but there's a responsibility of partners, managers, and supervisory lawyers. Responsibilities of a subordinate lawyer, responsibility regarding non-lawyer assistance, professional independence of a lawyer. Okay, communications concerning the lawyer's services. They didn't do any of this, so, well, there you go. Everybody has different issues in different courts, but always refer to the rules of professional conduct in the Code of Judicial Conduct. That doesn't happen, so you've been denied due process because you were denied a fair trial, because you were denied effective assistance of counsel, and effective assistance of counsel is described in the Code of Judicial Conduct and the rules of professional conduct, and these are the legal obligations of all lawyers and judges. So effective assistance of counsel is not just for that other defendant, the attorney for the defendant, but for the plaintiff, the judge. Everybody's required to abide by, enforce, and report any misconduct. Full names, reverse. Reporting professional misconduct. Okay. Lawyer who knows that a no lawyer has committed violation of Rule 8.4 shall inform the appropriate authorities of Illinois attorney registration disciplinary connection. Lawyer who knows that a judge has committed violation of applicable rules of the judicial conduct or raise substantial question of the judge's fitness for shall inform the appropriate authorities in Illinois. That's the Judicial Inquiry Board. A lawyer who has been disciplined, so nobody reports misconduct. Let me show you what misconduct is, okay? Misconduct is professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so through the acts of another. And since the state's attorney didn't report the judge for judicial misconduct, he can cite the state's attorney for prosecutorial misconduct, the judge for judicial misconduct, and legally they're supposed to report themselves for ineffective assistance counsel. Supposed to report anybody who violates the rules or the codes. Commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, fitness as a lawyer, or other respects. And they're not playing by the rule of professional conduct. So there you go. Engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. I think I already went through that with you. Engage in conduct is prejudicial to the administration of justice. State or imply the inability to influence properly government agency to achieve results by the means of violate the rules of professional conduct or other law, meaning the codes of judicial conduct, even the law, the rule of law. Violating the rule of law it's breaking the law, or the letter of the law. The letter of the law clearly states this must be done word for word to the letter. If any lawyer tries to tell you it doesn't mean what you think it means, that's disinformation, and that's illegal. Okay. Knowing or assist a judge, judicial officer in conduct that violates the applicable rules of judicial conduct or other law. Present, participate, present, or threaten to criminal or professional disciplinary charges to obtain advantage in a civil matter. Okay, so there's a lot of stuff you got to read. It's going to take too long. Disciplinary authority, choice of law. But like I said, everybody's got a different case. Everybody's in a different court, family court, child court, conservativeship, probate, no matter what court, state, federal, the rules of professional conduct always apply. I had to go through an eviction twice, and I won both times. It was a wrongful eviction. I proved it in court. It was just out of spite. But the judge mostly didn't like that. When I filed for an appearance, I didn't get a lawyer. I filed an appearance, appeared pro se. I filed for a jury trial. I asked for a quick and speedy trial when I got in there, which rarely anybody ever asked. The judge or lawyers won't mention it to you, but that's your legal right, your constitutional right to a quick and speedy trial, which is really ridiculous because they won't bring it up if you don't, just like they won't bring up any of this. If you don't know, nobody's going to do this. People ask me continuously, why do I have to learn this? Why do I have to take copies with me to court? Well, number one, you're not going to remember all this. Number two, they're not going to admit that this is the law if you don't say, hey, this is the law. You show them the rules of professional conduct, the code of judicial conduct, the complaint forms, and they drop like rocks. That's how I beat Social Security. They turned me down, and the last appeal, they turned me down, so I wound up suing them, and they capitulated because when I went back to court, they had to decide what they were going to give me. They tried for supplemental, but I wanted disability. I wanted my red, white, and blue card. They didn't want to give me anything until I mentioned the codes and the rules, and before I left the court that day, they capitulated, gave me my back pay, gave me my red, white, and blue card, and none of this will come up in court. So you bring up any of this, and it's a win-win situation, okay? So remember, okay, so let's go back here. See, Illinois Supreme rules of professional conduct. And if you're in Illinois, you want to find another state. I know some people that moved to Illinois had some issues in other states. So just if you're in another state, Wisconsin rules of professional conduct, whatever state you're in. And then also after you type in the rules of professional conduct, type in the rules of professional conduct complaint form, the code of judicial conduct, and the code of judicial conduct complaint form. And they will have addresses where you'll know exactly where to file these complaints. Okay, so that's part of, giving you that reasonable information to make an informed decision before you give informed consent. There's still a lot more to go, okay, because we got to go over the code of judicial conduct too, because it's impossible, just like in the rules of professional conduct and the code of judicial conduct, it's impossible just to violate one code, and remember, this is due process. And due process is based on a fair trial. You didn't have a fair trial if you didn't have effective assistance of counsel, and effective assistance of counsel is guaranteed in the Sixth Amendment of the U.S. Constitution. So if you didn't have effective assistance of counsel, which you didn't have a fair trial. It makes due process null and void. Okay. So these are all key. This is all one big puzzle piece you got to put together, and that's what I teach on my page, Legal Reform. Okay, thank you and God bless. I didn't mean to make this too long. All right, but there's going to be a lot longer ones. Check out my YouTube page. It's called The Vent. Okay, there's more videos there. I'm on TikTok, and I forgot what the other one is, but I'm as an unaccompanied adult. I'm on Facebook as Legal Reform, and this is all I do. The only thing you spend with me is time, okay? That's it. I don't ask for money. I don't ask for donations. I ask for nothing but your time. That's all you'll spend with me on legal reform. Thank you. Good day, and God bless.